Now we begin from the Court of Appeal. The BBI case entered the second day with impassioned pleas for the judges to overturn the damning High Court judgment. Lawyers representing the President, the BBI Secretariat and the IEBC faulted the High Court for what they termed as a misreading of the Constitution. And as our very own Sam Ogina now reports, the respondents will now take the floor tomorrow to defend their case against BBI.
On the last day of submission by the proponents of the BBI referendum drive, lawyers stepped up their arguments, seeking to convince the 7 judges to throw out the High Court judgment. The BBI Secretariat dismissing assertions that President Uhuru Kenyatta was the promoter of the initiative.
Honorable Dennis Waweru says that I and Honorable Junet Mohammed are the promoters of this initiative. He then describes how they engage with the IEBC and describes how they collected the signatures. My Lord, that affidavit was uncontroverted. How do you ignore such a fundamental?
The BBI team maintaining that the task force and the steering committee formed by the President and which birthed the BBI report were not part of the popular initiative as provided for in the Constitution.
As of 30th June 2020, there was no task force, there was no select committee. And an effort to tie those two bodies to this initiative is therefore futile.
IEBC on its part faulted the High Court judges, accusing them of relying on a repealed section of the law as the foundation of its judgment. The commission aggrieved by the finding of the High Court that it lacked the requisite quorum of 5 commissioners to undertake the referendum exercise.
The law that the court purported to rely on to find that there was no quorum was no longer law because it had been declared to be unconstitutional by a court of competent jurisdiction.
So do you have a problem with that declaration as it stands, that before you can have the referendum, because they're saying before the referendum,
yes,
before you can have the referendum, there should be a nationwide voter registration. Is that a problem?
Yes, my lord. It is a problem in this sense. It first presupposes, because it comes from a concern that was raised by the petitioners, that there is no voter registration going on. And my lord, it's not just about registration.
But if you actually are doing it, it means they are declaring that which is already happening. Why do you have a quorum?
President Uhuru Kenyatta on his part told the appellate bench that the High Court had condemned him unheard. His lawyers telling the court that the judges ignored the legal provisions giving the president immunity from litigation while in office. The president's defense team charging that the head of state was never served with any court documents during the proceedings, a fact they described as a travesty of justice.
The president was never served with the proceedings, despite the fact that he was sued in his private capacity. The breach of fundamental rights in relation to litigation are so serious, the courts have consistently found that such an order or a declaration is a nullity.
Do you agree with that finding at paragraph 494?
Yes.
That in establishing the BBI steering committee, your client did that in his official capacity as President and Commander-in-Chief of the Defense Forces?
The allegations, the petition, were personal. But rather, he sued in his personal capacity. But the allegations went to his official capacity.
The next 2 days are now reserved for the respondents to defend their case against the BBI. The Court of Appeal scheduled to wrap up the hearings by Friday. It remains unclear when they will give their verdict, but proponents of the BBI have appealed for a speedy decision as the 2022 election calendar closes in. Sam Ogina, Citizen TV, Nairobi.